In this video, you will watch arguments made by Kapil Sibal with regarding to Aziz Basha case, which was decided in 1967 by Supreme Court. In this case, it was decided that AMU was not a minority institution. The court decision was based on the fact that the British Parliament and not Muslims established the university in 1920. The court also ruled that AMU was a central university, which meant it would not be considered a minority institution. In this video, you will watch the points made by Kapil Sibal on the same judgment with regarding to the AMU.
Even if you were to look at the 81 amendment, 81 reinforces what, according to you, is the correct position even before 81.
That's right. So, therefore, you can look at it.
We'll
and if you decide against us, then that question will arise. So, let me quickly now finish with this,
Yes.
Now, having said that, kindly now see what Basha decided. So, we know we've done well. Now, what are the correct statements in Basha? Kindly look at factual aspect, so that I don't waste your lordship's time. Kindly come to page 9 of volume 3A. Yes. It says, kindly see placetum A and B, statement of fact. Further, it seems that the existing MAO college was made the basis of the university and was made over to the authorities established by the 1920 Act for the administration of the university, along with properties and funds attached to the college, the major part of which had been contributed by Muslims through though some contributions were made by other communities. This is a factual statement, correct. Nothing wrong with that statement. It only shows what? That we are the ones who set up the university. And that 30 lakh today, if translated today, into 2006, as translated, it would be 280 crores. And today it'd be 500 crores. So, Basha accepts is the MAO college was in existence. It was made the basis of the university. And the properties and the funds attached, that means everything in the college was handed over to the university. And the section itself says so. So the genesis of it is correct. That Basha affirms. So it was now number 2 is come to page 14 now. I'm just indicating the facts that are accepted by Basha itself. It says that brings us to the end of section 19 sections of 1920 Act. Your Lordship has sorry, it's not there. Page 14. Yes, kindly. The next paragraph between B and C, sentence starting, the annexure to the 1920 Act. Your Lordship has that? Between B and C at page 14.
Yes, the last
annexure to the 1920 Act gives the names of the foundation members of the court 124 who were all Muslims and who were to hold office for 5 years for the commencement. So, the factual statement, correct, indicates the genesis. Then come to page 15. Third paragraph, fourth line, between placetum C and D. It is remarkable that though the proviso to 23(1) was deleted as far back as 1951, there was no challenge to the 51 Act till after the ordinance of 65. Factually correct, Nobody challenged it. The reason for this might be that there was practically no substantial change in the administrative setup of the 1920 Act, and it is only when a drastic change was made by the ordinance of 65 followed by the Act that challenge was made not only to the 65 Act but also to the 55 Act, insofar as it did away the proviso of 23(1). So factually, Pasha acknowledges that nothing changed, despite the 51 Act. Acknowledges that fact. And what was the proviso? That all members of the court shall be Muslims. That's the third issue, factual issue. Fourth, page 16, top of the page. The statutes was right. That's a term A. May I read it? The statutes were also amended and many of the powers of the court were transferred by the amendment to the Executive Council. Further, the constitution of the court was drastically changed by the amendment of the 8th statute, and it practically became a body nominated by the visitor, except for the chancellor, the pro-chancellor, the members of the Executive Council who were ex officio members, and 3 members of Parliament, 2 to be nominated by the Speaker of the House, and 1 the Chairman of the Council of States. Changes were also made in the Constitution of the Executive Council. Finally, the 65 Act provided that every person holding office as a member of the court or the Executive Council, as the case may be, immediately before the 20th day of 65, shall on and from the said date cease to hold office. It was also provided that until the court and the Executive Council were reconstituted, the visitor may by general or special order direct any officer of the university to exercise the powers. So this tells you, this is the reason for challenge of the 65 Act. Correct, mothers? That's why it was challenged. Now come to page 17, top of the page, Placetum A. Yes. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational institution provided it has been established by it. So, mother, that's the statement of the law, provided we have established it. So that's correct also.